If there is no other questions from the court, I would submit on the papers, and I thank the court for its time.
Thank you.
Thank you.
You set it up for 20 minutes, right? So he had 18 minutes. I had much less time. And that's not fair.
Well, you're out of order right now. See, we have a gentleman up here who's ready to speak. He's got 2 minutes and 41 seconds. Now, you could share a minute or so if you want.
Well, let me get through my arguments, Your Honor, and I'll be happy to refer to
Okay.
if it please the court. I listened with great interest to Mr. Dist. What he essentially was saying in part of his comments was that he was urging that Congress would in effect be acting as a judicial body and making determinations as to who is eligible and who is not, whereas it's our argument that that is the province of the court. He also talked about the idea of Congress passing laws retroactively deciding who is eligible. And that's how we get back into this problem with the minor parties. We have the Republicans and the Democrats. We have some independents in Congress, but compare them to the major parties, and they are powerless except in a close vote to make any difference whatsoever. So we still have the issue getting back that the courts need to be involved in this and need to take a stand to enforce the Constitution. Now, regarding the political question, it's our argument that eligibility is not a value judgment or a policy decision, as is required for the political question. It's a yes or no answer to a question. Is someone eligible subject to the evidence that's submitted, or is that person not eligible subject to the evidence? So it's not we would argue that, with all due respect to Judge Carter, that it's not a political question. With regard to the court's involvement in cases such as this, it's very limited, but we submitted the Cleaver v. Jordan case, which went all the way up to the United States Supreme Court, which the U.S. Supreme Court refused to hear, allowing the affirmance of the California rulings, which stated that the Secretary of State had the right to remove someone from the ballot. Now, by the time this all got to be done, it was post-election, I understand, but they affirmed the right of the state of California in this case. The Secretary
they just didn't hear the case.
Yes, they didn't hear the case.
They didn't hear the case. That doesn't mean anything.
Well, but they allowed the lower court decision.
Well, they do that. They do that all the time because they got a lot of other things on their agenda.
I understand, Your Honor.
You know, they've got plenty of work.
Your Honor, yeah, I'm sure. I'm aware that they do. Your Honor, in sitting and thinking while Mr. Dist was making his presentation, it occurs to me, and I don't have the experience that Your Honors do, but I've been doing constitutional law for 35 years, that on other issues, if we had brought it before the election, as I've done in other instances, then we're told it's premature because you don't know who's going to get elected, so you can't really challenge anybody's election. Then if you wait till after the election, then you're too late. The election is done in response to one of the questions about what the change point is, where the sea change is, and it's that. I would respectfully suggest, and my time is up and I apologize, that Your Honors review the Irby case, which we submitted, where there's a discussion about the problem with elected bodies making determinations as to who is allowed to run for what in the sense of ongoing political campaigns. And I thank Your Honors for your time.
Thank you very much.
Well, just to add a few
words. You use your time.
No, I didn't. I still have some time.
Much time. He got 20 to do it.
What did you say?
She didn't get as much time.
Okay, go ahead.
Okay. Just to add a few...
You got my timekeeper over here.
Yeah. He said 20 minutes for Mr. Crape instead of 10 minutes, so the whole thing was messed up.
Well, you have 20 minutes to divide between the two of you.
Yeah. So originally Mr. Crape spoke for 18 minutes.
No, he didn't speak for 18 minutes.
Yeah. He set it up for 20. When he started speaking, so he spoke for 10 minutes.
Why don't you just go ahead?
Yeah. Anyways, what is important here is that my client, Ambassador Keyes, was the presidential candidate running against Mr. Obama. So he had perfect standing. Additionally, we went to Congress and I presented during the hearings in the district court letters from a number of senators. Specifically, I recall a letter from Senator Sessions stating that the Senate cannot decide the issues of fraud, whether fraud was committed, and eligibility, that it is for the courts to decide. And the senators specifically stated that they want to abstain because they're not the court of law, they're not judges, they cannot decide those issues. And therefore, it has to be decided.
When did you submit those?
Oh,
Is it after the election or before?
Before.
In other words, when were the senators deferring to the courts? Was it before or after the election?
The letters were sent to Judge Carter. We have sent letters to senators, congressmen. We had a whole campaign.
Was this after the election?
We've sent letters before and after the election. Nothing was done. Not only that, my clients, members of the military, went through Article 138, which is a specific article of grievances. And I submitted, you have it with my pleadings, a letter from the chairman of Joint Chiefs of Staff of U.S. military, from legal counsel for Admiral Mullen, saying that yes, we appreciate this is an important issue, but because Mr. Obama, Commander-in-Chief, is not considered to be technically a part of the military. He's a civilian overseeing the military. There is nothing they can do. So we did go and we tried each and every avenue. We exhausted each and every avenue, reaching Chairman of Joint Chiefs of Staff. We went to Congress, we went to Senate, and rightfully they said it's up to the courts to decide. The senators cannot evaluate evidence. They cannot say if this birth certificate is valid or forgery. That's up to the judge to decide, and that's why I'm asking to overturn this decision and give me an opportunity to try this case on the merits and obtain proper evidence, and then submit it to Congress.
Listen, we have your argument well in hand.
Yes.
Okay.
Thank you.
Thank you very much.
Thank you very much.
And we will now adjourn until tomorrow morning at 9 o'clock, and thank you for your attendance.